Good afternoon, viewers. I welcome you again to the seventh episode of IFA-India Academy's International Tax and Transfer Pricing Update. I have two expert panelists with me, and let me introduce them to you right away. To my right is Mr. Rajat Bansal. Mr. Rajat Bansal is Joint Secretary FT and TR, Central Board of Direct Taxes, and one of the chief architects of the treaty amendment that we are going to talk about as one of the key topics today. So welcome, Mr. Bansal. Facing me is Gokul Chaudhri. Gokul Chaudhri is a partner in BMR Associates LLP, and he heads the direct tax practice at BMR. Am I right, Gokul?
You're completely right, Amitabh, and I can also say that we are former colleagues, and therefore I'm glad to be with you on this.
Thank you, Gokul. So thank you for both of you to brave this heat and come to our office. I hope we have a cool discussion on a topic which has been taking our focus for the last 2 weeks, ever since this has come into public domain. So we have two topics today, and we will start with our main one, which is the amendment to the treaty between India and Mauritius. And while treaty is the short form, let me just take your indulgence to give the technical correct term. It is called Convention for the Avoidance of Double Taxation and the Prevention of Fiscal Evasion with respect to taxes on income and capital gains between India and Mauritius. So you can't even read the whole thing in one breath. So it's quite a diverse, long thing, but covers probably the whole breadth of the agreement that we so far call treaty. So first question to Mr. Bansal. This news that has been always floating around. Last 10 years we have been thinking, and every time we hear about it, we get the jitters. The stock market catches a cold, and then the clarification comes. No, we are thinking about it, but so far nothing has happened. And finally, as we say in Hindi, "Bakri ki maa kab tak khair banayegi." So it's happened, and tell us, Mr. Bansal, what was happening behind the scenes, and how did it culminate in what it did?
See, as everybody is aware that this treaty amendment was being requested by India for very long. It was maybe for last 20 years that this was being asked for. Ever since this Indian economy was liberalized and the foreign institutional investments started coming through Mauritius, even though the persons who were coming were not belonging strictly to Mauritius, from then itself there has been a request from our side to amend the treaty.
Mm-hmm.
Now several efforts were made, which are in public domain also, and several groups were constituted, but somehow, because it's a bilateral thing, the two countries have to agree.
Mm-hmm.
So it could not be finalized, and for one reason or other, it was always stalled. So anyway, there has to be some point of time when things get crystallized. So I think the BEPS project at this time, and the international tax environment at this time, that which is looking at tax avoidance as something which should be discouraged.
Mm-hmm.
All these things played some role in this, and it also depends on the present team there also, which is negotiating with us.
Mm-hmm.
So taken all together, I think it was the right time when this happened, and it's very difficult to say why it happened now and why it couldn't have happened earlier.
But was the negotiation on equal terms, or India was the big brother driving the negotiations?
No. Negotiations were on equal terms. In fact, India's negotiations with all countries are generally on very equal terms.
Mm-hmm.
And yes, we have very good relationship with Mauritius, so they would be different from some other country negotiations.
Mm-hmm.
But I would say that they were on equal terms only, because as you would see from the protocol, several aspects have been are there which clearly show that the concerns of both sides were taken into account, and
Mm-hmm.
accordingly it was something done to gradually move to a new regime So it was on equal terms.
So, in couple of public interviews, you have said that the changes that have been made in the treaty reflects the new drive or new focus on source-based taxation and the prevention of fiscal evasion, which I guess is coming from the BEPS initiative. So all the changes, barring maybe the grandfathering provisions, does it create a new template of a model treaty that India will now look at signing with other partners or renegotiating?
All India's treaties, as see, the main article which has undergone change is capital gains on shares, as we all know. So, if you have a look at India's treaties which have been signed, or then recently in the last 6-7 years, then the effort has been to have this particular provision to have source-based taxation.
Right.
So wherever it is not there, our effort has been to change it to source-based taxation.
Right.
So it is not that this is a model, but rather it has fallen into line with the model which we are trying to follow.
So it's more of an alignment.
Yes, it's more of an alignment.
Okay.
And this brings this treaty in line with our treaties which we have with other countries. And as a developing country, our emphasis on source-based taxation.
Okay. So Gokul, before we go into the nitty-gritties of all the changes, any immediate thoughts?
Well, one of the things that Mr. Bansal spoke about was, of course, the impending work of BEPS, which had an influence on the treaty and maybe the timelines of the treaty. And I'm also very curious as to whether the imminent rollout of GAR in India on the 1st of April 2017 coincidentally ties in with the dates that are mentioned in the treaty protocol. So I wonder as to whether the GAR also played a role in how the timeline for this treaty really worked out. So that's one dimension to this. And I think the capital gains provision which Ms. Bansal spoke about is not just important to investors. It is also important to both the countries. It's not just one country that was a beneficiary of that provision. The fact is that in the early years of our liberalization, close to 50% of our foreign investment was really coming through the gateway of Mauritius.
Right.
And in later years, which is now, between Mauritius and Singapore has a co-terminus clause with Mauritius, close to 50% continue to come from it. So really, did India benefit? India did benefit, not from a fiscal perspective, but from a capital perspective. And Mauritius benefited because it was trying to create itself as a financial services offshore center for this part of the world. So there was a benefit there too. And of course, the investors that came in also had a benefit, which is here. So I think, so my only sort of comment would be, did GAR feature in the negotiating room?
Yes, definitely GAR was in the horizon, and everybody was aware of GAR being there. Yes, one can see that in any case, GAR is going to come from 1/4/2017, the date from which these changes are also going to come about. But you see, one must realize that the treaty is going to apply across the board. Whereas GAR is kind of, even if it is there, it is kind of a post-mortem exercise.
Right.
So the guidelines that are being framed, even otherwise, it's known that GAR will apply, say, let's say about 5 crore transaction, or a committee of high-level officers will examine it before they before invoking GAR or before giving a finding of impermissible avoidance settlement in a particular case. So that way, even if one was aware that GAR is going to be there, still this would have many pluses in the sense that it will apply across the board.
Right.
So I think it also is very interesting that the solution that was built into the treaty for ensuring that you balance, or the protocol to balance, on one side the desire to have a treaty that stands the test of future time in a BEPS world, in a GAR world. And at the same point of time, you don't want to do anything that sort of upsets and brings uncertainty or retrospectivity impact to investors. I think it was a very close balancing that had to be done between these two twin objectives. And the solution around the grandfathering of all legacy investments which have been made up to 31st of March 2017, I think that's a very unique feature. It's a helpful and a very desired feature, but it's very unique. And I don't know who to give the credit to for having found this, whether it's the Indian side or the Mauritius side, but whoever did find it and agreed to it, I think came up with a decent outcome.
Yes, I would say
We
that.
must find the grandfather. He has to be thanked. So coming back to the changes per se, and let's take them through one by one. Gokul, the first change is, of course, in Article 5, a permanent establishment, where a new service PE concept has been brought in. And while everybody is talking about the capital gains and grandfathering, I personally feel, and that this probably has some level of mischief, and I want to open up with you. Do you see any problem here?
Well, service PE clause sits in a number of treaties that India has around the world. It's not a part of the OECD framework, but service PE is a feature which is there in the UN model, and India follows that model. What is different is the fact that when the OECD model convention was being commented upon, India made a statement that we reserve our rights insofar as whether the service PE constitution requires physical presence of employees or other personnel from
in the other state.
in the other contracting state. So just to explain the concept, you really create a service PE historically if you have sending employees or other personnel to, let's say, from Mauritius to India, and if they go beyond a certain threshold of presence in India, then a service PE comes into rise. But the words within the contracting state, in the context of this protocol that has been brought in, those words within the contracting states are missing, which effectively means that a service PE could theoretically be constructed by mere rendering of services across the boundaries without an active presence in the ground by any Mauritian company having employees in India. Now, one could have said that, is this a sort of rush of all the other things, and since capital gains was this big thing in the big gorilla in the room, this got left out. I don't think it is as simple as saying it got left out. The omission of these words has to go back to India's reservation to the model convention OECD, because India did express a view there very clearly, saying that we do not agree with the principle, and we would like to have an outcome where even without personnel being in the country, a service PE could be constituted. So I think if I read that reservation of India and I read these omissions, I think what is happening is that the source state, which is India in this case, in our example, could well assert a right to tax, and could assert a right to tax with all the outcomes that a PE does create, which is net income based on taxation and so forth. The minute the services are even rendered from outside of India, but the services cross a threshold.
So if I have, Mr. Bansal, if I have a company in India and I enter into a consulting contract with a company based in Mauritius, which is for the full year, and they give me certain advisory, fund management and other advisory, does it mean that just by giving those advice and having a contract which runs across that period, it will constitute a permanent establishment?
No, I don't think so. My interpretation of this is that for the threshold period, probably the presence will be required of the personnel.
Okay.
Because if you read it in conjunction with Article 7, it says that for the purpose for which Article 5 is created, to be used in Article 7. So ultimately, in Article 7, it is said that the income which is attributable to a permanent establishment situated in the other contracting state.
Right.
So there is a question of situation, situs. So I'll have to look into this further, but at the moment, I feel that personnel's presence for the threshold period would be required before we give a finding for the permanent establishment.
And isn't that something which is logical?
That's very logical, and that's goes at the heart of it. But I think our concern is, why did those words go missing, and did those go missing with the backdrop of India's reservation where this view was expressed? So I think people may be trying to connect, and maybe they're unconnected pieces, but that's the concern which is coming in, because it's no denying the fact that a number of fund managers, as you correctly said, could well be based in Mauritius, and they could be rendering services into the Indian entities in India.
And
No, I can think of them being taxed under as fees for technical services, because first there we are talking about managerial consultancy or
Right.
technical services.
Absolutely.
There we will go by the utilization of services in India and not by the presence of
That's right.
personnel.
Yeah.
But here my understanding is that threshold period presence is required. Anyway, this I'll have to first further examine.
Okay,
and
so
see.
there is a glimmer of hope that, as Mr. Bansal said, that we are trying to align the wordings to other treaties. In other treaties, the presence thing is quite very well
Prominent.
expressly mentioned. So let's see. We have
Yeah.
hope, Mr. Bansal. So moving forward to the interest clause, and we'll come to capital gains after that. The this clause, why did it need tinkering? Because on first blush, I thought that this was all right. The source country had the right for taxation also. Why bring in a rate? Why carve out the banking company separately? Just some light you could shed on this.
See, first thing is that the amendment in the by putting in a rate of 7.5% withholding tax rate in the source country. So earlier there was no ceiling
rate.
or nothing was prescribed.
Right.
So all our treaties, India's all treaties have a rate cap on in the
Upper
source
rate,
country.
yeah.
In the source country, this is the only exception. So we are aligning. We always try to align our treaties with each other whenever an exercise of amendment is going on. And there is another reason, as per the OECD commentary, which we are not a member of OECD, but the reason given there for putting a cap on the source country withholding tax rate is that in any case they are going to tax the profits arising out of the borrowed capital. So their share of revenue out of the interest income should be capped. So with that logic, they put in a cap. And in all our treaties, we have a rate of mostly 10%.
Right.
So here it is also this rate cap has been put.
So is this 7.5 is a bonus just for Mauritius, or do you see this 7.5? I mean, I'm just looking at most favored nation and other things.
No, it's not a bonus. You see, this is a matter of negotiation. Whenever two countries are taking a decision on a package, ultimately what they would agree upon. So in more, you will find, if you analyze our treaties, you will find the rates ranging. There are two-tier rates which are split between two kinds of interest, 5% or 15%. You will also find. So it's not something which is away from the band which we have with other countries. So we cannot read it as some concession exactly. It's a reasonable rate looking at all the parameters and depending on the negotiations. Ultimately, we had 7.5%.
So Gokul, do you see some ECBs being?
Yeah, absolutely, Amitabh. That's one of the first things that really people started looking at and said, Mauritius was very good for bringing in equity flows. Does this change in the provisions now make Mauritius equally attractive from a debt flow?
Yeah.
Because the structure that existed in the treaty before in Mauritius was very simple. If you are a banking company, you did not have any withholding on interest, but everyone else, you are as per the domestic law of India, which meant 20% rate would apply for a large chunk of the interest that would really flow from India. So really debt would not really be pooled and structured out of Mauritius. Yeah. I think what Mr. Bansal spoke about earlier, that we've had a good diplomatic and political relationship with Mauritius, and in some ways this debt provision continues to reflect that Mauritius continues to be the preferred jurisdiction for a number of capital flows into India.
And its economic relevance will remain.
Absolutely. And here we therefore see a 7.5%, which is in some ways for a regular non-banking sort of taxpayer, is it is the lowest, because we've got 10% in a number of OECD countries, we've got 15% in others. And we must recognize that there are certain domestic provisions where the interest withholding is 5% currently, which is there. So there's no denying that in some situations, domestic law could actually be more beneficial than even the treaty. But then you've got this you've got this basket of rates, but within the basket of rates, among the treaty rates, 7.5% means that India has given a certain structured outcome for Mauritius while taking away certain other benefits that may be in relation to equity.
So if I connect the dots, it's a give and take,
which is the core of any negotiation, I would imagine.
Okay. So then coming to the fee for technical service article, Article 12A, which has been inserted earlier, there was no fee for technical services article. So I guess that comes in the whole thing of aligning with the UN model where FTS is definitely present. The wordings are the standard ones. Do you have any specific things on FTS?
Well, as Mr. Bansal said, here was a negotiation of a treaty, and you're going to try and make this treaty comprehensive. Actually, if at the end of this whole exercise, if they had not put in an FTS clause, we would have actually looked at the absence of that clause and then started scratching our heads and said that's an anomaly. So there would have been more eyebrows raised if this provision had not come in. So I'm glad in that sense the treaty is complete from a very standard text perspective by having an FTS clause within it.
Okay. So, although I think OECD is no longer recognizing FTS.
No, OECD never had FTS.
Right.
I mean, on our insistence in our treaty, it is there with OECD countries also.
Right.
With some variations like fees for included services.
That's
in
right.
case of USA.
US and UK.
With having a whole lot of memorandum of understanding on that. So, it's more of our creation or more of on our insistence that this has been there. So here also, because it was absent here, and this is in principle in line with our source-based taxation practice. So therefore,
so are you going to fill this gap in all the treaties where FTS
is there mostly?
Are there still countries out there where we can take other income?
I think Malaysia used to be without FTS, but I think that got plugged too.
Malaysia, I'll have to check.
Yeah. Okay.
I'm not sure whether it is there. But mostly, as far as I'm aware, FTS article is there.
And if they are not there, you're going to hunt them, find them, and fill them.
I mean, whenever the occasion arises for amendment, or if we find that it is affecting our tax base, then we take this.
Actually, this provision could be advantageous to Mauritius too, because if you have a Mauritius-based fund, let's say a debt fund or equity fund, and it is making payments to an Indian service provider for information
investment advisor,
right, which is there, then they will have the right to withhold as FTS. So it works both ways.
So Mauritius could get some revenue because they have withholding tax provisions.
Correct.
Yeah, that could be.
We are clear that we are fair in that. I mean, if it is to be taxed there, as per our consistent stand, then it has to be taxed there also.
So let's come to capital gains, and there my question is to you, Gokul, because you meet clients, you have an eye and ears towards the business. What do you see the ramifications of the capital gains clause? I can split the question into three. How future investments would be structured, what happens to the current investment structure, and what would be the impact to Mauritius? And there I would leave the question open to both of you.
Sure. I think let's try and look at it. There was a fair bit long period of time when this treaty was being negotiated or renegotiated. There's a bit of a cry wolf, a lot of theories sort of floating around, what will be the LOB clause looking like? Will we really have a treaty negotiation, or are we going to run into the guard period and then, everything will really open up and get messy? And those are the type of concerns which are there. And let's not deny the fact that this treaty has had its challenges in the sense that we had a PIL on this treaty, which went all the way to Supreme Court and so forth. So there was a fairly large body of uncertainty that was really coming in here. So the first sort of message out here is that as far as the legacy investment, which is there, and as I spoke about, from 91 till 2016, we've done a quarter century of liberalization in this country, and the largest stock of FDI really sits from this one gateway. I think the grandfathering clause brings a great degree of certainty and a comfort to investors. And even more so that the LOB sort of provisions haven't been made applicable for those investments as we read the protocol. Coincidentally, the protocol has put out on the Mauritius website. So really, when we look at that outcome, I think it's a happy outcome that the investors who relied upon the rule of law in India, who used the benefit of the Mauritius Treaty, structured themselves. They went with the very base eligibility rule, which was you have to have a tax residency certificate. All of that stuff remains secure. So India is no longer going to do a repeat of what happened in 2012 when it carried out a set of changes which really upset the investor sentiment and
spooked the stock market, everything.
So I think that part has been very well addressed in here. What also came as this bit of a pleasant surprise is that they actually put together some sort of a transition mechanism. To some extent, when we read the press release, the concern was, how is this transition mechanism really working? The protocol language makes it quite clear as to what it works. I think one concern that really works in there is that there is a LOB, a limitation of benefit, that sits during the transition period, which is there. One overhang is a bit that this is the transition period when you really will have the GAR sitting in here. And as Mr. Bansal said, the GAR guidelines are probably going to be coming through to the public domain. And maybe the certainty and the clarity may emerge when you co-read the GAR guidelines. But until the GAR guidelines come in, there's sort of a bit of concern that, how does the LOB and the GAR, how will they sort of sit together, and will they give us equal outcome of certainty, which is there. I think what will happen on future investment, I think if you look at it immediately, there were a number of people who were fence sitting for a while as far as Mauritius were concerned, because they said, don't know where the treaty is going, don't know what's going to happen, do we really walk into this treaty at this point of time? I think all of those fence sitters will actually be very confident to make the investment from now up to the end of the year, and maybe even beyond that into the transition period with some confidence on the treaty, which is insofar as all the debt flows are concerned, they will again be very confident because this treaty offers a capital gains exemption still on the debt instruments, and also the interest rates withholding has been given an incentive, which is there. Plus, I think we need to recognize that over the 20-year period, Mauritius as a jurisdiction for pooling monies from different jurisdictions has matured. Mauritius has also become the gateway to Africa. So therefore, a number of Indian entrepreneurs wanting to go to Africa may actually look at Mauritius as the stepping stone into Africa. Plus, the rule of law, the commercial laws, the contracting laws, the banking system, all of those things have matured over the last 20 years in Mauritius. So I think there are certain key advantages that Mauritius offers beyond the capital gains exemption. And I think that will hold it in good stead as far as it's concerned. But of course, as we have a lot of dust to settle. The dust has yet to settle on BEPS project, on the multilateral instrument, on GAR, and so forth. So I think it's a little too early to say that, is the Mauritius story over? No, I don't think it's a Mauritius story. It's going to take a different journey, but it still will be a relevant investor into India.
So on the FDI map, Mauritius will still be a major blip. It will not fade away. That's your feeling.
It will carry more than its fair share of weight into the Indian markets.
That's your feeling. So, Mr. Bansal, my question is that I think we have been kind in a way to the investors or to Mauritius or to both by having a what we call a grandfathering clause and a phased out exemption. So what was the objective of doing that instead of just pulling the plug?
So first thing is, as I said, it's a bilateral negotiation. So it's not that one can, it's something which two sides agree to.
Right.
So that's a secondary aspect. The main is that from our point of view also, we would like to see stability of the investments. And as per the, the policy of the government, that we don't want something to come up suddenly which will disturb the planning or the commitments already made by people and the taxpayers.
Right.
So therefore, grandfathering was a natural outcome of this kind of thinking, that investments which have already been made are protected. And that's what has been done in GAR also. GAR is also not applicable to investments made before 1/4/2017.
Right.
So this is in line with that. As far as transition is concerned, now here also after a great deal of discussion, it appeared to us that maybe a phasing out of this kind of exemption will be better from the point of view of the taxpayers. And and the other side also we have to take into account.
So this was more coming from the other side?
No, from our point of view also, we feel that it's a reasonable, I think that even if it was an other side proposal, we also found it to be a reasonable proposal. Instead of imposing tax straight away from a particular date, a phasing out proposal would make appear all right to us.
It wouldn't cause much agony.
Yes, because ultimately it's a matter of 2 years only. So after 2 years, it's going to be 100% tax.
Right.
So my little bit of question on this is, assuming a GAR gets grandfathered till 31st March 2017 on investments, during the 2 years transition period, you still have the principal purpose test sitting in the LOB for Mauritius.
Primary purpose test.
Yes. How will that behave vis-a-vis GAR?
See, the LOB is, as you said, is applicable for only the 2 years period to avail of 50% tax benefit.
Right.
Now, there are three conditions. One is this primary purpose test, one is the shell company test, and the third is bona fide business. So these are all ingredients of a general anti-abuse rule only.
Yeah.
So when we are talking about question of the interplay between the two, we should think that what would be the situations which would be falling outside LOB and still getting covered under GAR. So would there be any such situations? If there are any, then obviously because of the domestic law that GAR will override the treaty, GAR will apply. But practically speaking, how many such situations will be there, and that too in a period of 2 years only. So
with a short-term capital gains.
Yes. So therefore, it's definitely it's an issue. It's something to be which is being asked again and again. But I think that one should look at its practicality. But
right.
As far as theoretical answer is concerned, the answer is that if there is a situation which is not covered under LOB and it's an abusive situation and gets covered under GAR, then GAR will apply.
So I had this question saved for later, but since we are talking about it, let me frame a hypothetical situation. I set up a company after 1st April 2000, or I make an investment after 1st April 2017, and blatantly, it seems very obvious that my intention, a primary purpose, is to take advantage of the benefit from the treaty. But I make that expenditure, the threshold of expenditure, that 15 lakh Mauritius rupees that I have spent. So as per the LOB, the way I read it, I'll be deemed to be a resident if I have spent that amount of money.
No, I don't think so, because I think that the first paragraph of the LOB would apply independently of the shell company provision.
A resident of the contracting state shall not be entitled to the benefits of Article 13(3)(b) of this convention if his affairs are arranged with a primary purpose to take advantage of the benefits in Article 13(b) of this convention.
So, therefore, this itself will apply.
So it applies to a shell or a conduit company.
Yes.
Now, if you read 4, a resident will not be deemed to be a shell and a conduit company if its expenditure meets this criteria.
I think, the issue which is there is that only takes you out of the clause 2. Clause 1 continues to apply even if you are able to meet the threshold of expenditure. So you spend more than 15 lakhs in Mauritius, you're no longer deemed to be a shell conduit company, but it still leaves you, the tax officer, with the powers to question you under
subjective powers.
Under one.
No, objective. You can say subjective powers in the sense that it's a decision not based on a number. It's a decision based on analysis of facts of a case.
Right.
But yes, as he says, this particular provision will apply irrespective of whether it's a shell company or a not a shell company.
So I may get out of being a shell or a conduit company, but I may still be trapped
Yes.
by the primary purpose.
Yes.
Is that that's the
And that's going to be a difficult one to come out of.
Yeah.
I mean, we've had some very old, if you remember, cases that went on in the 90s where we were able to demonstrate that in Mauritius, the contracting frameworks and commercial laws enabled it to be a far more efficient pooling country, and therefore, investors from different countries had sort of created these pooling vehicles. But the question is that, will the taxman accept my argument that there was a purpose for coming out into Mauritius, which was outside of tax, and tax certainly was one of them, but it was the primary purpose was not that. The primary purpose was to have a very efficient jurisdiction for pooling. Now, I don't know who's going to put the weight on which, because beyond these two really arguments of the tax benefit and the efficiency of having a pooling jurisdiction, there are very few other reasons that you can really justify and put on paper or in conduct to say that what is your purpose for coming through a jurisdiction.
So maybe GAR is lesser of the two evils because it is probably has a more structured way it will be applied. There is a threshold. There will be a quasi-judicial body to determine.
Whereas clause 1 does not carry those checks and balances.
So an assessing officer could himself invoke this kind of a limitation.
See, all I can say is this is kind of similar to the Singapore LOB.
Right.
Rather, it is exactly
it's a copy
same
paste,
as Singapore LOB.
Only the amounts thresholds have changed.
And the working of the Singapore LOB, as far as I have found out, is working all right. I mean, it has not caused any major concerns as far as I am aware of. So I don't see much reason to be concerned about this LOB, especially for a short transition period of 2 years.
Yeah.
And that is the only period when GAR and this LOB will both be operating.
So let's wait and watch.
I think Amitabh also what carrying forward what Mr. Bansal is saying. If the intention is to apply this in all cases, then really the transition mechanism will never work. Because it will fail. So if the intention is to give a real outcome under the transition mechanism, then I think the liberal thinking has to sit on the application of clause 1 equally.
So it has to be, as I say, it's subjective. So that takes me to the second, the next question, and this is to you, Gokul, that we have time till 1st April 2017, where we, if we make any investment till then, we continue to be grandfathered and we have complete exemption. Does that, sort of create a rush of people trying to get in? Will the, LOB or GAR get, somewhere in trying to prevent that?
I think only those investors, really, commercially speaking, who were shying away from making an investment through Mauritius because of the uncertainties, they may feel more confident and they will continue to make the investment through Mauritius now. I don't think anyone's really going to put in a lot of money through a Mauritius structure for no purpose in India and hold that money thinking tomorrow that money may become useful in India, and therefore tomorrow if I have a capital gains threshold to meet, then because I brought this money in before the 1st of April 2017, I will have the grandfathering. I don't think investors are going to be taking such a point of view because no one wants money to be lying idle.
Right.
So I don't think people are going to pump in money only for the sake of pumping in money.
Okay.
There'll have to be a purpose.
A business connect.
Correct.
Yeah.
And to that extent, I don't think for a lot of strategic investors, long-term investors, this threshold of 6 months, which is there, is actually a very material one. I think only those who are on the cusp of making these different investments may actually do that in the most logical way.
So 1st April 2017, was it timed as Gokul's theory is to align with GAR, or it was just a clean break?
See, we are now in May 2016.
Right.
And the treaties take some time to enter into force also.
Okay.
So, we work according to our financial years. So that, I think that would be the closest. So looking at it from that point of view, that is more because of the reason of being the closest financial year when it could have been implemented than any other reason.
So it was convenience rather than...
No, not convenience. You see, we want to change urgently and immediately. And the closest we can change it from would be 1st April 2017, because that is the next financial year.
In some ways, it fits in neatly with everything else that goes on.
So we shouldn't draw any inferences.
I'm so glad that it's not any other date, because then we would be dealing with that intermediate period,
fractional period.
So there's I mean, that date is because of coinciding it with the financial year, and so that makes it a smooth thing in every aspect.
So coming to Singapore, and as you mentioned that Singapore Treaty, when it brought in the exemption for shares, it made it co-terminus with the Mauritius Treaty. So what happens now, considering that there is a staggered phase out? What is your reading?
Well, there can be two schools of thought around here. One is the way the amendment has taken place in the Mauritius Treaty. The capital gains on alienation of shares, that exemption continues. And really what they've done in the protocol is make a carve out that this exemption does not apply to investment made after the first day of April 2017. So if you want to be a very aggressive, bold investor,
optimistic,
yes, you can probably take a point of view and say, look, the Singapore Treaty says that this exemption in Singapore continues as long as the alienation of shares in Mauritius continue to be exempt. Well, the answer is, well, alienation of shares continue to be exempt, but for certain category of shares which are after a certain date. Now that is one sort of way to look at this. But I don't think, given the scale and size of investment registering, that either the investors would like to walk down such a interpretation, nor would the two countries would like to leave such a large amount of area open to potential, and this will be litigation. Given the fact that this government has been very keen to try and not create a litigious situation, they will have to provide for some certainty and clarity. And that will only come through a bilateral negotiation between the two countries. From what's been put out in the public domain, it appears that there will be a negotiation.
So you don't think the co-terminus event will happen automatically? That the
co-terminus would happen, but the grandfathering is something you cannot read, certainly in the treaty. And you can't read the transition mechanisms into the treaty in Singapore. So those will have to be very explicitly brought in.
Okay. But the termination, you think, can happen automatically, or does that need an executive action?
That, as I said, you can play with the words if you want to take an argument. I don't think investors would like to play the words the way I described it in the beginning, to try and take the belief that the treaty continues to give an exemption.
What is your input on that, Mr. Bansal? See, Article 6 of the 2005 protocol with Singapore, that says that Article, I think, 1, 2, 3, and 5 of the protocol will be enforced only as long as there is a provision in the Mauritius Treaty about taxation of capital shares on residence basis. So, going by that, it's linked directly and an automatic inference. But as Gokul says, we are working on it, and let us see how we go about it. And I mean, it is automatic, definitely, but since there are other things in the other protocol, so what is automatic and what is not, we'll have to see.
So, what is so? Are you going to look at same kind of grandfathering and a phase-out clause? Too early to say.
Too early to say. Let us see, because one thing is for sure, that the residence-based taxation under Singapore Treaty is also being linked directly to Mauritius Treaty, ends after change in Mauritius Treaty. What would be the exact mechanism to bring it about? we cannot say now, but there's no denying the fact that the two are interlinked, and it is an automatic fallout of the one.
So their destinies are tied together in a way.
Yes, that
in
is
a way.
obvious from reading the protocol, Article 6 of the 2005 protocol.
But hasn't it put some jitters on the Singapore investors, considering that while Mauritius investors are really
Well, all of those who are very cautious and move from Mauritius to Singapore could well consider going back for a period of time if they want more certainty until the two governments iron this out.
But do you feel, looking at, obviously this is crystal ball gazing, but if I was an investor, would you say that you have faith in the present government and something fair and just would come out between Singapore and India?
I think there are two parts to this. One is the fact that the investors will be, of course, very nervous at this point of time, because anything which is under negotiation, the outcome of a negotiation can be anything.
Mm-hmm.
But I think they'll also take a lot of confidence from the fact that how India and Mauritius have resolved the issue. They have done it in a very sensible manner. And they've come out with an outcome which has not been hurting of legacy investment. They protected the legacy investment from any untoward damage.
Mm-hmm.
That confidence building up is something which I expect will be there for even the Singapore investors. And that's the confidence they will carry. But while you carry that confidence, when the negotiations take place, it's always a bit of an uncertainty as to what really will emerge. And whether the outcome will be identical, similar, or if it's dissimilar, how dissimilar will it be?
Right. So, considering that negotiations are always long drawn effort, is there certain effort being made to have this negotiation quickly and to put this to bed?
It will not be possible for me to get into that.
Okay.
But yes, it is, as we can see, Article 6 of this protocol definitely has to be implemented.
So I think we can just wait and watch and hope for the best. I guess that's where we should look at. So moving forward, but one question I had on the capital gains, that what has been taken away is the capital gains exemption on shares. And that's where the Mauritius treaty also has taken away, and Singapore treaty also provided the same. So two questions relating to that does shares here mean cover preference shares, convertible, non-convertible? And does that clearly leave out any other form of investments, debentures, units, everything else?
The word used is shares in a company.
Right.
So preference shares, I think, would be automatically covered. When shares in a company we are talking about,
right,
in Article 3A.
Right.
So other than that, all other asset classes are covered under the residuary category,
which continue to be exempt.
Yes, and that is the practice in all the treaties, and that is the practice in the UN model and in our most other treaties. So for other asset classes, the right of taxation is with the country of residence.
So do you have any issues with that? Especially there have been questions asked that if you have convertible debentures and things.
So I think the question is going to be around all the hybrid instruments that really play around. And I think there's been a growing concern because, you've got new accounting standards, you've got ICDS, you've got a lot of other stuff which is floating around, which is now raising a question on the classification of a lot of these instruments. So I think one of the other aspects is, of course, the convertible debentures, for example. Then, how will you classify convertible debentures? Do they really need to be converted into shares before the 31st of March 2017 for them to really qualify as shares for the purposes of grandfathering? Or they can continue to be CCDs and be converted at the point of time where they are supposed to be converted, and they will continue to carry the feature of being grandfathered because the instrument got really put into play a long time back. So some of those aspects are really going to be interesting to see. I don't know if there's going to be any clarity or coming into some of these features, because I know the P notes, for example, have been talked about. There's also some amount of discussion on, indirect transfers, because as you correctly said, sir, that direct sale of shares is something from the 1st of April 2017 is going to be there. But what about indirect transfers? You know, if supposing there's a Mauritius company holding another Mauritius company, and then you have underlying assets in India, and if the top Mauritius company sells the shares of the bottom Mauritius company, assume for a moment there's no GAR invocation in the structure. The right to tax under the treaty should fall in Mauritius because they do not become shares of an Indian company. So indirect transfer, for example, of shares is something which Mauritius should be having the right jurisdiction to tax. So some of these nuances are still sitting there, sir.
Yes, certainly. I mean, there will always be some situations and issues which will come up after you come out with a solution. So fresh solution will have to be found for such.
So you mean you're still leaving some space for tax advisors to
earn their bread and butter, huh? So it's good. You know, you should be happy. You'll have clients. If all questions were answered, then nobody would come to you, Gokul. So be happy. So coming to the two new insertions which have come in, which is, or rather, EOI, exchange of information, seems to be identical to what the Singapore treaty was. What seems to have, perhaps it was there in Singapore, nobody looked at it in so much detail, but now that everyone's focus is on Mauritius, that it doesn't restrict the scope to the persons covered under the treaty, and doesn't restrict the scope to just the taxes covered under the treaty. So it's any taxes, whether it's national, state, municipal, any kind of a person, whether a resident or otherwise. So two questions linked to that. One is, what caused this overarching scope to be funneled through essentially a tax treaty? And second is, do you have, if one looks at Section 90 as giving you the powers to enter into a treaty, to actually have an exchange of information which goes beyond the Income Tax Act?
See, the article is now as per the international standard. The OECD model has the latest version of Article 26 is in 2012. So now this particular treaty has adopted the it has been this particular 2012 formulation has been adopted in the India-Mauritius treaty now.
Mm-hmm.
And as you might be aware that the world over there is a lot of emphasis on transparency and exchange of information.
Mm-hmm.
So all the treaties are required to be updated to the international standard.
Mm-hmm.
So therefore, in Singapore, this was done in 2011,
mm-hmm.
and now this has been done in Mauritius in 2016.
Mm-hmm.
So this article is standard, international standard.
Right.
There is no, there is nothing different from the international standard.
Right.
Second aspect is this, that paragraph 1 says that this will operate irrespective of Article 1 and 2. Mm-hmm. That is the personal scope as well as the taxes covered.
Right.
Now there also, first I'll take up the taxes covered. Taxes covered is the OECD international standard is to have it there. I mean, to cover all kind of taxes for exchange of information. Mm-hmm. I'll have to think as to why Section 90, if there is any conflict with this, but I don't think there would be any for exchanging information on other taxes. This question I'll have to think and answer to. But this, otherwise, I can tell you that in as per the OECD's model, the other taxes information can be exchanged. Mm-hmm. And about the persons who are not residents of either contracting state, mm-hmm. if there is a foreseeable relevance which requires information to be collected in respect of them. Suppose mm-hmm. a non-resident is having some transaction in India, mm-hmm. which is leading to its taxability in India, right. and some information is required for that. Mm-hmm. So just restricting it to residents would mm-hmm. put a bar or a kind of a shackle to get information in respect of such person. So this mm-hmm. is also as per the international standard. And in fact, I can tell you, our experience has been that absence of this in some of the treaties has caused the other country to say that we are not obliged to exchange information about the persons who are not resident of our country. Mm-hmm. Whereas this information is very much required, foreseeably relevant for implementing our tax laws here. Mm-hmm. Therefore, these are these articles are this particular feature of the EOI article is correct.
It's correct based on present times.
Yes, and as per the international practice.
So I just, before I come to Gokul, I had one thought that you already have a multilateral instrument to exchange financial information, automatic exchange of financial information. I believe 80 odd countries have already signed it, where just having a bank account or a security in that country requires information to be exchanged. And it was in that context that I was looking at this treaty change in the scope. So, Gokul, any thoughts? Does this you look at it positively? You have concerns?
Well, India as well as Mauritius have both been very active participants on most of the global forums that have been there on exchange of information. And as I remember, they're both signatory to the FATCA, for example.
They're both signatories to MAC, that is the Mutual Administrative and Assistance Convention.
Right.
Mauritius ratified it recently.
Okay.
India has been there for very long.
So we've seen what has happened is that most of these nations are now sort of converging on the fact that information has to flow seamlessly and virtually automatically between most of the governmental agencies. So I think what Sir is saying is correct. This sort of provision is in line with the OECD convention. And I think that's a new reality in a new world where we have to live with, where privacy is very little and transparency is a new mantra. So I guess that's a new reality. That's how provisions are going to be working. Whether or not they really need to be sitting through the flow of Section 90, etc. These are very, these are remediable issues
Right.
because the intention of most nations is now that information exchange will move without barriers and without constraints. And that's the behavioral pattern we are seeing.
So if there are any things missing in the domestic law, they will be amended
I
suitably.
don't think it would be missing. I have to just look into the missing link
Okay.
to explain this.
Okay.
I think that there's nothing missing.
So we'll move forward. I think LOB we have already discussed. The only query I had from you, Mr. Bansal, was that you have been mentioning that in forums that interplay with if a conflict happens between GAR and LOB, although your personal view is that there will be very little scope for that conflict, the GAR would override.
Yes.
And that brings a larger worry about the provisions of the domestic law sort of encroaching the sanctity of things enshrined in the treaty.
No. I think there the international understanding is quite clear. The OECD Model Convention commentary already was clear that the domestic general anti-abuse rules can override the treaties. And the latest Action 6 of the BEPS plan, there a lot of discussion is there on this. And there also they have sort of endorsed that general anti-abuse rules which are there in various countries would be operable despite the treaty being there. So there is not much. I think there is not much difference of opinion there. The report is quite clear on that.
So and do you think the line will stop there at GAR, or other aspects of domestic legislation will start encroaching into the areas of the treaty? That's my question to Gokul. What do you feel? That is it a slippery slope?
I hope not, because the big debate has been always on GAR, and I thought the intention was that GAR really gets invoked when you have a abusive behavior. And when India did bring in GAR initially, of course, it was something which was looked at as weaponry, which made investors and taxpayers very nervous. And that's what led to a number of checks and balancings being introduced in how the working of GAR will happen. So I think GAR will be hopefully used far more selectively and in highly abusive frameworks. And in that respect, treaty override was prescribed to make sure that people cannot take shelter under treaties to camouflage their abusive behavior. But in respect of remaining provisions, other than of course now again Section 94, which has been a bit of a controversy. I think the Azadi Bachao sort of Andolan's statements, which are there on the Supreme Court, is something which we need to all rely upon. That the treaty is something which gives a benefit to taxpayers, and it needs to be overriding the domestic law provisions.
But we'll come to that. Hold on to that before we come to that particular thing, which is a cue to our next topic, which we'll discuss briefly. Just one question, Mr. Bansal, that we have the press release. Thanks to the Mauritius government, we have the text of the protocol. What is the next step? How are things going to phase out? Is there going to be a notification?
Yes, yes. See, the entry into force article of the, like every other protocol amending a treaty and the treaties, there is an entry into force article, which is the usual formulation is that the two countries are required to notify each other through diplomatic channels that their domestic procedure to bring it into force is completed. After that, the later date of the, whenever is the later date of the notifications by the two countries to each other, on that particular day, the treaty enters into force, or the protocol enters into force. And in India, the procedure thereafter is to notify it in the Gazette of India.
That's right.
So those formalities are being completed, and after that, it will come into force. And as far as timeline is concerned, in any case, it has to be before 1st April 2017.
So just for Ramal, in India, we don't need to carry this to Parliament.
We don't need.
In India, we need to carry it to the Union cabinet. Is that how the process works, or does it need a ministerial sign-off?
All these treaties are approved by the cabinet. We take cabinet.
Okay. So the protocol, which is there, will then go into a cabinet approval process?
No. Before signing that.
Before signing.
Okay.
So thereafter,
so all those approvals have been taken.
But there are still some formalities which we have to complete before we notify the other country.
Okay.
And is it to be placed at least in the parliament, or it doesn't have to be placed there also?
I'll have to check up. I don't think it is placed.
Okay. Yes. Because that question was picked up in Azadi Bachao, that is it an executive, our treaties have the force of the parliament, or is it an executive action? So I was just curious.
No, see, here they are by virtue of Section 90.
Right.
The power
so
is
delegated
given to the government under Section 90.
Okay. So I will wait for some light on Section 90, because Section 90, as it's currently stated, restricts you to enter into agreements only in relation to evasion of income taxes and any other tax in the act. So that's where the query was coming from. So now moving forward, you raised the question of Azadi Bachao, and since we are almost done with time, we'll take a very quick view on that. There is a Madras High Court judgment which recently came in relation to Cyprus, because Cyprus was notified as the bad boy and an uncooperative jurisdiction, and a 30% withholding was levied. And when Azadi Bachao Andolan was put before them, they said that the order has deviated a little bit, and the treaty cannot override or cannot be in conflict with domestic law, and if there's a conflict, the domestic law prevails. So matter is now in Supreme Court. There's an interim stay, but Gaurav, Gokul, do you see this going? Do you have a concern with the way the jurisprudence is going in this?
Let me break this into two parts, and that's two parts because there are two parts to a human brain. The left side of my brain, which is very interested in academic work in tax, says, wow, this is delightful because now we've got a jurisprudence building up where we're going to have international tax or international law, read with domestic law. How does the two work? How does the constitutional provisions work vis-a-vis Section 90? And how does the treaty laws under Vienna Convention work with our constitution? What's the powers of parliament? So there are lots of very interesting questions which are sitting in there, and I don't think the final word is out because that will come from the Supreme Court as it's built up. So we got the High Court decision, and I've read it with keen interest as an academician. But I am a reader of the judgment rather than an expert on constitutional law and international law to be able to say, has the court really grasped every nuance of it appropriately, or is this something which has been missing the point here. So in that respect, I think there are 2 or 3 things which are coming out as a reader and not as an expert. The first is that, the court is saying very clearly that just like Parliament has the powers to create Section 90 and thereby give the executive the powers to execute treaties, it is also recognizing in the Constitution that the Constitution says India shall respect treaties.
Which is a directive principle.
It's a directive principle. Which also means that India has, or the Indian Parliament has the powers to deal with when treaties are not respected. And if there's an absence of exchange of information, and there's a bad behavior on a disrespect of a treaty by another sovereign, really what should India do is something which Parliament can legislate, and that's what Parliament has legislated in Section 94. So the Parliament has legislated Section 90, given the powers to the executive to execute treaties, and it has created Section 94 and said if there is abusive behavior between sovereigns, and what do you do to be able to, as an executive, notify that as a non-corporate jurisdiction, and what you can do with them. So in that sense, the High Court is saying there is no conflict between 90 and 94 because those have certain working in certain frameworks. And just because you could have dealt with the situation under Section 90 through the treaty, through a map, etc., all of that stuff, doesn't mean that the Parliament doesn't have the right to enact another provision to enable how even a treaty can be rescinded. For example, they have not used it in the order, but my wordings would be that Parliament can actually notify what are the circumstances in which the government can rescind a treaty, just as you have the ability to sign a treaty. But that's more the space.
So are you saying that you agree with the Madras High Court?
Now, coming to that part where I will sort of refrain from being trolled in social media and say, I think the final word will come from Supreme Court. Yeah. But my other side, the right side of the brain is, more of a tax practitioner, and I'm sort of bemused because, why am I bemused? I'm bemused because I look at the dates. And this transaction is a $3 million purchase. $3 million. This is not a $3 billion deal. It's a $3 million deal. It's a $3 million deal.
But 20 crores.
18 crores to be more precise.
Right.
And it's done in the year 2013-14. Now, if you rewind the clock to 13-14, everybody in this country was aghast with the fact that in 2012, we had the retrospective change of law in relation to the infamous Vodafone case, the overturning of a Supreme Court decision, the taxation of indirect transfers. We had withholding tax being imposed, and there's a whole heated debate in this. And here is this taxpayer, and typically I, as a tax practitioner, I have a lot of sympathy for taxpayers because I'm on their side of the table for most instances. But here I don't seem to have any sympathy because I'm saying, you know what the environment was. There is a very precise Section 94. It says you have to withhold. The remittance you're making is $3 million. You're supposed to do 30%. You go and take a legal opinion. Okay, so it's not that this section was not known to you. And then you decide that, you know what? I will challenge the constitutionality of this provision. But I will not obey with this provision. So I'm sort of saying that, yes, while we put a lot of onus on the government at different times, say, why does the government litigate everything? And we should have a litigation mukt Bharat, one was uses of word. But this, to be creating constitutional law on a $3 million transaction in the backdrop of this environment, I get bemused.
So all things being the same, if you were the advisor, you would have clearly asked them to pay the tax.
Or take a withholding order.
Yeah.
Because the court in page 3 or 4 itself acknowledges that other than this constitutional challenge, there are no merits to the case.
Right.
That's what they write.
That's right.
Which means I'm doing a $3 million deal. I have no merits to the case other than going to question the constitutionality of this provision.
So then you have no sympathy that rather than accept the Madras judgment, they have gone to the Supreme Court now.
So I'm just sort of wondering as to whether we are now trying to create a situation of a debate on some things of the provisions which could have been living harmoniously.
I agree with you. So, Mr.
But I
Bansal,
enjoyed the debate.
Mr. Bansal, I'll take. Of course, you're from the department, so I guess I cannot make you say something which goes against the department's position. One thing I noticed in the court, the court said that 94A was the need of the hour. So it took into cognizance that countries have to now cooperate with each other, and if they don't cooperate, then the treaty cannot just be respected by one side while the other continues to flout it. So is that the sentiment that is going around in the department and in all the negotiations?
No, this particular provision is with respect to exchange of information.
Right.
So we cannot generalize it to the working of the entire treaty. So as far as exchange of information and transparency is concerned, they are on a different platform these days. All these Panama leaks and before that Lux leaks and everything is revolving around transparency.
Right.
So transparency is on a pedestal for quite some time. And in 2009, G20 also said that it's quoted in that decision also, this Madras High Court decision. They have, in fact, quoted extensively from the proceedings of that G20 meeting.
That's right.
So, therefore, need of the hour is, I think, is reference to the need to have mechanisms to ensure exchange of information, to have transparency. That is what all the TRs are about. That is what this automatic exchange of information and CRS is about. That is what FATCA is about. So this is an emerging area in itself.
And if you don't comply, then there is arm twisting.
No, see, you look at it from the other side. What would you do if some country is not at all ready to provide you with information?
I think we're coming to a situation where if a treaty, the higher the benefits you're seeking under a treaty, the greater is the onus of transparency under the treaty. I think that's sort of going hand in hand in here. And Cyprus certainly enjoys a very advantageous treaty. And the question was that, there is then an equal amount of onus on compliance with the exchange of information. You can't have one without the other, else you will have Section 94 really kicking in, hurting you very hard.
And
so, even if there is no treaty with, not call them, I think we should call them countries where there is no tax system, there is no formal tax system. So those countries we have tax information exchange agreements.
Right.
And there's a lot of emphasis on them in the Global Forum on Exchange of Information and Transparency.
Right.
So the focus is on those countries also, even though they are not availing of any treaty benefit, because they are being used as conduits to come through some other country. So, I mean, that's what I'm trying to convey, that exchange of information and transparency is in itself something which is to enforce which a lot of steps are being taken, and 94A is one such step.
So if there are in future, if there are other countries or jurisdictions who behave in an uncooperative manner,
it acts as a deterrent also. Yeah. You see, when 94A is there on the statute and a case is there, then I cannot name, but I know that several other countries which were not supplying information earlier are supplying beautiful information.
So is it like FATCA? FATCA also had that carrot and
stick. Yeah, that's how it works. So, I guess.
So one should not judge India in saying that 94A is harsh or it's abrogating the treaty. Is that what your heart says? Forget about your head.
I think several other countries also took similar measures.
I think we need to recognize that information exchange, which was just another provision that started in the treaty, and really many of us would not even have bothered to read those provisions very diligently, in this new world, are a very integral part of bilateral treaties. And really, I think breach of that protocol is seen as extremely bad behavior, which can, as Section 94A demonstrates, can actually lead to a very harsh outcome.
So is that the mood, prevailing mood? Transparency.
Transparency is one of the three pillars of the BEPS action plan also.
Yeah.
So transparency is very important.
And India in letter and spirit is firmly.
Yes, India is one of the front runners in this matter, and in global forum, India is always been in the forefront. It's a member of the peer review group. It's a member of the steering group. So, and it's a member of the AEOI group. It's one of the early adopters of the CRS.
It's
So
the
we are
earliest
going to-
adopter of equalization levy also.
And in fact, what is to be done to implement the CRS?
Right.
India is one country which has taken all the steps to implement the CRS.
So definitely, India has everything to gain from a lot of these legislations. So Gokul, before we wind up, any final words?
So I think I'm glad we've had the words of wisdom and clarity from you, sir. You were in the thick of it, and I guess you're going to probably have far more insights on what's happening in this entire domain. So whatever you shared with us today was very, very useful, and I thank you for that.
So thank you, Mr. Bansal. I hope the clarity on Singapore Treaty emerges soon, and we get a news that a new treaty has been negotiated, and we wish it's as good as the Mauritius one. So Godspeed, and thank you for joining us. Listening to this episode, and on behalf of IFA Academy, I thank Gokul and thank Mr. Bansal to be with us, and hope to see you again soon. Please do subscribe to our channel to get regular updates. Have a nice day and a great weekend. Thank you very much.